Evicting a tenant can seem like a complicated undertaking, but in this video, we'll quickly explain eviction laws in West Virginia and how to recover your property in 5 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state requirements can be found on our website. Legal reasons for eviction in West Virginia. A landlord only has grounds to evict a tenant for reasons allowable in the state. West Virginia is particularly unique in that landlords aren't required to give a tenant a notice to quit before filing an eviction action in court. However, such a notice does exist, and it's always recommended to serve the tenant notice of intended action. Landlords can always choose to give the tenant a set amount of time to correct small violations, but again, this is optional. These are the reasons for evictions in West Virginia. Non-payment of illegal activity and non-compliance. If the tenant does not pay rent, commits a lease violation, or engages in illegal activity, the landlord may deliver an immediate notice to quit, which requires the tenant to vacate immediately without option to cure or with a time limit to correct at the landlord's discretion. Rent grace period. In West Virginia, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if rent is only 1 day late. 5 steps to legally evicting a tenant in West Virginia. Serve the notice to quit. Optional. If you choose to serve a notice, download and fill it out on eForms.com, or hand deliver the notice to the tenant, or post it on their door if they're unavailable. If you'd rather proceed directly to court, you can skip this step. File eviction papers with the court. Proceed to the magistrate court in the area where the property is located to file the following: complaint, also called a petition for summary relief, wrongful occupation. Tenant's answer. A hearing will be scheduled within 10 days of filing. The tenant will have up until the hearing to file an answer, which details their side of the story. Attend the hearing. At the hearing, the judge will reach a ruling. If the tenant doesn't respond or attend, or if the judge rules in your favor, a judgment will be issued which will order the tenant to vacate. Removing the tenant. If the tenant still remains on the premises, you can request a writ of possession from the court, which, if granted, authorizes the sheriff to remove the tenant. Often the tenant's security deposit does not cover total losses. If damages are not awarded at the hearing, you may be able to recover past due rent and court fees through small claims court. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.